matter of Chugh and Chugh.
May it please your lordships, I appear with Miss Barons on behalf of the appellant.
Yes.
My learned friend, Mr. Wilkinson, King's Counsel, and Mr. Smith, here for the respondent. My lord, I'm conscious that there should be a link to the respondent. Doesn't appear to be.
No idea. How do we know whether it's working or not?
May I get the name? Is it Sandeep?
Sandeep Chugh.
He is here. He's currently muted.
Okay.
Ah.
Thank you.
My lord, permission was granted by your lordship, Lord Justice Moylan, on the 10th of November 2029.
Yes.
Lord, I propose to address matters in the following way. First of all, to set out the statutory framework. Secondly, relevant case law. Before turning to my submissions, rather than saying the appeal should be allowed, considering the judgment of Mr. Recorder Allen, King's Counsel, against the relevant legal framework. And my lord, I submit that there are two principal reasons why this appeal should be allowed. Firstly, because the learned judge failed to take into consideration procedural requirements for service having regard to English standards. And secondly, he failed to take into account that when the husband knew the wife was living in England and the parties were engaged in proceedings in England and indeed in India, at no time did the husband inform the wife or the court of the Indian proceedings. There was a lack of plain dealing. And that the failure by Mr. Allen, his counsel, to take those two matters into consideration renders his judgment plainly wrong, and this appeal should be allowed. So, my lord, turning first of all to the relevant statutory provision, my lord, at page 6 of the authorities bundle is a copy of section page 3, sorry, of the authorities bundle is a copy of page 4, section 45 of the Family Law Act of 1986.
Yes. Excuse me.
My lord, you will see that that provides that subject to sections 51 and 52 of this Act, the validity of a divorce obtained in a country outside the British Islands shall be recognised if and only if it is entitled to recognition by virtue of sections 46 to 49 of this Act. And Lord, there's no issue that the divorce is effective for the purpose of section 46, so that requirement is satisfied. So moving on to section 51 of the Act. The relevant provision is section 51, subsection 3. Which states, subject to section 52 of this Act, recognition by virtue of section 45 of this Act of the validity of an overseas divorce, annulment or legal separation may, or the writing of a may, be refused if, subsection A, in the case of a divorce, annulment or legal separation obtained by means of proceedings, it was obtained Roman numeral 1, without such steps having been taken for the giving notice of the proceedings to a party to the marriage, as having regard to the nature of the proceedings and all the circumstances should reasonably have been taken. So the question is, in a nutshell, whether reasonable steps have been taken to give notice of the divorce to the party, to the marriage.
Just before we leave that, could I ask about the second in Roman 2? Because as you helpfully read out, the preceding words obtained by means of, if it was obtained, and then you've got two limbs which are in the alternative. Roman 2, it seems to make clear by the words in brackets, for any reason other than lack of notice, that it's dealing with an opportunity to take part in the proceedings. But you're not dealing with limb Roman 1 at that stage.
No.
No. That's what I thought. They fit together in that way. I mean, the judge happens to have applied both, but this was a case under Roman 1.
Exactly.
Yeah.
Well,
But on the other hand, the legal considerations about English standards and so on might apply to Roman 2 as well, and considerations of comity and so on.
I would agree.
Yeah.
Yes.
I just wanted to catch up. Okay, thank you.
And the word used or words used have been taken for giving notice of the proceedings. I can't remember whether this has been addressed in the authorities. It's not, doesn't use the word service. It just uses the word more generally, giving notice. In other words, drawing them to their attention. Has that been addressed in the, you'll come to it when we come to the authorities.
So, you've seen that the authorities in regard to this issue are, first instance, High Court decisions. There doesn't appear to have been Court of Appeal decision addressing this particular, the application of this particular provision. The authority which is most frequently cited is that of Sir Richardson, King's Counsel, as it was in the case of Chugh against Chugh, Attorney General intervening in Volume 2 of the Family Law Reports, page 1042.
Yes.
The relevant points that have been frequently cited in the cases in that decision.
Can you just tell us about the facts of that decision? There had been proceedings in Nigeria.
Yes.
Divorce proceedings, obviously. And what had happened in what had actually happened in those proceedings in respect of the wife having been given notice of those proceedings? Can you remind me?
Well, just turning to the page 42.
Yes.
In terms of the Nigerian proceedings, well, you can read from the head note, Lords, that in terms of the English proceedings, rather, when the decree nisi was about to pronounce the husband, it seems to assert he'd already divorced in Nigeria. It emerged that shortly after the wife had issued her English divorce petition, the husband issued a Nigerian divorce petition in which he'd alleged that both he and the wife lived in Nigeria and that she had deserted him for another man. Although the husband, aware that the English Child Support Agency intended to take action against him in respect of the child, had only the year before arranged a face-to-face meeting with the wife in London to discuss child support. The husband did not inform the Nigerian court or his Nigerian lawyers that the wife lived or might live in England. think that, submit that, my lords, is potentially significant here also, when I come to my submissions. The bailiff in Nigeria was unable to serve the wife's notice of the Nigerian proceedings at the address given by the husband, and the Nigerian court ordered substituted servants by pasting the petition to the property at which the wife supposedly lived. The Nigerian court later granted divorce in the wife's absence. The husband now sought to stay the English divorce, arguing that the English court was bound to recognise the Nigerian divorce as a valid overseas divorce. And yes, the divorce in those circumstances will always be rejected.
Yes, thank you.
So I will return to paragraph 44, which is where Mr. Richardson sets out the points.
Yes.
Well, it's perhaps instructive to go through those points, unless your lordships don't.
No, of course.
So paragraph 44. It seems to me that the relevant law can be distilled into the following propositions. Note, when I refer to petitioning spouse, I mean the party seeking the divorce, and respondent spouse means the other party, regardless of how they're described in the overseas jurisdiction. 1. The power contained in section 51, subsection 3 as a whole, and I think that that's perhaps relevant, my lords, as a whole, provides for a wide judicial discretion. Provisions need not be exercised if the interests of the respondent spouse, as opposed to the petitioning spouse, are met by other means. An example of this is O'Farrell against O'Farrell. It seems to me that it is important to emphasise that those interests must be safeguarded. I would anticipate that this approach would only be adopted where the respondent spouse has no option under the overseas divorce law but to submit to the divorce. The important point to note is that the judicial discretion is wide, and the applicability of the section will vary depending on the many and varied circumstances of each case. 2. When considering section 51, subsection 3a, numeral 1, the judge must ask whether reasonable steps have been taken by the petitioning spouse to notify the respondent spouse of the divorce proceedings in advance of them taking place. 3. In answering that question, the judge must look at all the circumstances of the case and the nature of the proceedings in the overseas jurisdiction. 4. Whether reasonable steps to notify the other parties have been taken is to be judged by English standards, having regard to the nature of the overseas proceedings. 5. Whether reasonable steps have been taken is a question of fact in each case. It must also be remembered that there are cases where reasonable steps have been taken but they were unsuccessful, or in rare cases where it is entirely reasonable for no steps to have been taken. 6. It is important to note that whether the respondent spouse has notice of the proceedings is not the issue. It is whether the petitioner spouse has taken reasonable steps to notify the other party. The focus of inquiry is upon the actions of the petitioning spouse, not simply a question of whether the respondent spouse knew about the proceedings.
2 questions. One is, judged by English standards. What does that mean?
Well, my lord,
Are you coming to that?
yes, but I can tell you, I submit that it means a number of things, having regard, first of all, to English standards in respect of service, so what the English and Wales courts might expect. But also, I'll come on to the case of Iblaver and Yates, but in that case, Mr. Justice Peter Jackson.
Basic standards of fairness.
Exactly. Plain dealing.
I mean, I can understand that it's the court is applying an English statute, and so what is or is not reasonable must be judged through that statutory prism. But I just don't. I'm puzzled about the English standards. The other thing is he right that whether reasonable steps have been taken is a question of fact? What steps have been taken is a question of fact, but whether or not they are or are not reasonable, is that not an evaluative exercise rather than a question of fact?
I agree with my lord that it is an evaluative exercise, yes. And I'll come on to this. But exercise, excuse me, takes place because in my submission of the reference to all the circumstances in section 51, subsection 3A, number 1. So that evaluation that I've submitted is important by the use of the expression all the circumstances.
Well, I would have thought possibly it's really whether by use of the word reasonable, whether something is or is not reasonable is the judge has to decide. It's not a fact whether something is reasonable. That's my view at the moment, speaking for myself. Yes, thank you.
In following up my lord's question about English standards, if we go back in to Her Johnson, just before the 6th, paragraph 44, he says on the previous page, 51 of the authorities bundle, he's found 3 authorities particularly helpful. See paragraph 41. Well, and D&D the most helpful. And we fortunately have that in the bundle, decisions Justice Ward, going back to paragraph page 23. And I was just noticing the penultimate paragraph on that page, starting with the words Miss Gumble submitted, well, the last 2 paragraphs. He responds to a submission she makes by rejecting it, and then he goes on to look at the interplay between section 46 and section 51.
I'm sorry, my lord, which page is?
23. D&D, the last 2 paragraphs on the page.
Yeah.
Which seems to perhaps provide a source for where this notion of English standards has come from.
Yes, my lord. In respect to that paragraph, or that judgment of Mr. Justice Ward, that submission is that if the section was in that way, as applying English law, the submission was that no Ghanaian customary divorce would ever be entitled to recognition, since the customary law of Ghana did not require the spouses to be parties to the proceedings or to be notified. And Mr. Justice Wall rejected that argument. And so his lordship was clear that at the bottom of that page, and accordingly, no doubt that under section 51, subsection 3A1, I'm exercising the wide discretion given to an English judge applying the English concept of what constitutes reasonable steps to give notice of the proceedings to the wife, having regard to the nature of the Ghanaian proceedings.
there might be a better way of expressing it, that applying the English concept of what constitutes reasonable steps than saying English standards.
It's looking at the relationship between 46 and 50 and 53 and the two legal systems. Anyway. And going back then to Lim Roman 2, you referred to fairness a moment ago. That might inform our standards of fairness, might inform the view you take about whether someone has had a reasonable opportunity to take part in proceedings.
Yes.
In a case where notice is sufficient.
Yes. With the natural justice law.
I see that Mr. Justice Wall also says that what constitutes reasonable steps must be a matter of fact. It may be that all he and Mr. Richardson were saying is that it's a factual judgment rather than a legal question.
Yes.
Yes, thank you.
So moving on, it's the next case which is pertinent to look at is the case of Olifisoy against Olifisoy No. 2 recognition. That's in volume 2 of the Family Law Reports 2011, page 564. This is a judgment of Mr. Justice Holman.
Sorry, hold on a second. I've just been told that the CVP link is not working. So what's going to happen is that the respondent is going to be sent the live stream link so that he can observe the proceedings through the live link. Is that all right, Mr. Wilkinson?
Of course.
Thank you. Thank you very much.
So this is at page.
Sorry, hold on.
Judgment is at page 59 of the authorities protocol. And again, it concerned, you'll see a case in Nigeria. In that case, the parties married in Nigeria, the husband was Nigerian, wife's parents were Nigerian. She spent substantial time, substantial periods there. She returned to England, and the husband resisted the wife's divorce petition on the basis that they were no longer married, and produced evidence that he'd obtained the divorce in Nigeria in the wife's absence. In that case, again, the divorce, the Nigerian divorce, was not recognised. And Mr. Justice Holman endorsed the 6 points set out in Chugh Johnson at page 66 of the authorities bundle, paragraphs 32 to 36. In paragraph 34, His Lordship set out having endorsed those 6 points, paragraph 34 said, third, it is very important to keep in mind that under the subpara there are 2 stages in the approach to the court. First, it must make an assessment or judgment whether such steps were not taken, should reasonably have been taken. But even if the court judges that they were not, that merely opens the door or gateway to the second stage, and an overall exercise of discretion whether or not to recognise the overseas divorce. And that mentions the Court of Appeal decision in Globovich. That case, Globovich, it's not before the court, but that case concerned provision of divorce under the recognition of that divorce under paragraph subsection over 51 3C, where it was contrary to public policy. The submission was made by counsel in that case, Mr. Adaremi, that the approach taken in Globovich, which was where it was found that to recognise the divorce would be manifestly contrary to public policy, then the decision could only be one way. That was rejected. And just continuing, so at the top of page 67, paragraph 4, His Lordship said that indeed, if in every case, whether falling under subsection A or B or C, there is no second stage discretion, the word may, where it appears in the opening words of section 51, would properly read shall. His Lordship continued at paragraph 35. In exercising the second stage of discretion, if the gateway is open and if it arises, the court should, in my view, still be very slow to refuse recognition of the decision and order the foreign court, at any rate when, as here, it is clear that when an independent, properly constituted court operating a procedure and applying substantive law, as is clear from the documents in this case, which substantially accords with our own. It is not simply a matter of comity or respect for the foreign court. Orderly legal relationships in the international world require that, so far as possible, judicial outcomes in one country can be relied upon in all others, provided there was, as here, a proper connection with the connected country. My Lords, despite having said that, Mr. Justice Holman in this case nevertheless refused to recognise the Nigerian divorce. So, my Lords, just in terms of the discretion, my submission is that if it's found that reasonable steps have been taken, having regard to the nature of the proceedings and all the circumstances, so taking the two-stage approach of Mr. Justice Holman, the gateway is through the gateway. Any discretion at that point must then be limited. It must be a residual discretion, because the court will have considered all factors, evaluated them as part of the exercise, as my Lord's already indicated, having regard to reasonableness, reasonable steps.
Well, what the court would then be doing is bringing in, having concluded that reasonable steps have not been taken, would be looking at and bringing in other factors for the purposes of determining whether or not, despite the fact that reasonable steps had not been taken, nevertheless the divorce should be recognised.
Well, I would submit, my Lord, that at that stage the discretion must be limited once you do that.
So your submission would be there would need to be powerful other countervailing factors.
But it's, of course, acknowledged that there's a discretion. I say, of course, it was disputed in Holgate, but the use of the word may and we don't take issue, but there is nevertheless a discretion.
Yes.
So moving on to the next case of the waiver from the Yates against Yates, second volume of the Family Law Reports 2014-26. This was a judgment of Mr. Justice Peter Jackson concerning a Ukrainian
Yes.
If I could draw your Lordship's attention to page 89 of the authorities bundle, paragraph 66 of that judgment, under the heading conclusions.
Can we just again, what the there were English divorce proceedings, and then unbeknown to the husband or the English court, the wife lodged divorce proceedings in Ukraine.
Yes.
And under Ukrainian law, a defendant had the right to be involved, right to have notice. Nonetheless, in September, a small classified advertisement appeared in a newspaper in Ukraine, whether available on the internet. Okay, thank you. Yes.
Yes. So there were proceedings ongoing in both countries at the same time. And I think the expression Mr. Justice Peter Jackson used was that she trailed her coat and indicated that there might be something going on in Ukraine, but then hadn't really gone any further than that. And so she'd then obtained the Ukrainian divorce and produced it as a almost a fait accompli. And so in that case, paragraphs 62 onwards, page 89.
Yeah, so in 62, he sets out the routes by which the husband could have, the wife could have notified or brought, the proceedings to the attention of the wife.
Email, text or telephone, place of work, by his friends, by his solicitors, by the court. So moving on to conclusions. Paragraph 66, His Lordship sets out, he states, I have regard to the fact that the nature of divorce proceedings involves an important change in the civil status of two people. I also note that the wife was actively participating in English proceedings relating to this marriage. Moreover, it would have cost her nothing in time or money to have given the husband information about the Ukrainian proceedings at a time when it might have been of use to him. Instead, she trailed her coat by giving information that she intended to start Ukrainian proceedings, but only provided information after it was realistically too late for the husband to do anything about it. Had the Ukrainian courts known what this court knows, I respectfully doubt whether it would have authorised service by advertisement as its first option, particularly as the husband had no chance whatever of coming across the advertisement. On the basis of the information provided by the wife, I do not accept that the Ukrainian court was told of the proceedings in this jurisdiction, including one set of proceedings in which the wife was petitioner. Had it been, it would surely have required information about them. The more difficult question that then arises is whether recognition of the Ukrainian divorce should be withheld. And then His Lordship goes on to set out factors in favour of recognition and against recognition.
It's interesting that although both Mr. Justice Holman and Mr. Justice Peter Jackson conclude pretty firmly that reasonable steps are not taken, they still both regard the discretionary question as a difficult one. Mr. Justice Holman says it's a question of the utmost difficulty and very finely balanced, paragraph 70. Mr. Justice Peter Jackson says it's the more difficult question, although both, in fact, come down in favour of refusing recognition.
Yes. So, Mr. Justice Peter Jackson, as he was, says at paragraph 69, in favour of recognition, owing to avoid the undesirable situation whereby the parties are regarded as being married in the wife's country but not in the husband's. 2, these parties are going to be divorced anyway. 3, recognition does not bring any readily ascertainable disadvantages to the husband. And 4, any financial issues can be resolved in this jurisdiction through Part 3 matrimonial and family proceedings at 1984. Paragraph 70, against recognition. The wife misled the Ukrainian court by representing that the husband could not be found. 2, as a result, the husband was deprived of all opportunity of participating in them directly or of making applications concerning them in this jurisdiction. 3, the problem of the limping marriage is likely to be a short-term one. The parties will probably soon be divorced in this jurisdiction, limiting the period of anomaly between the two systems. 4, non-recognition brings no particular disadvantage to the wife. And 5, this is not a case where both parties are foreign nationals and the foreign court represents a natural forum, an example being the case of Wolof-Isor, where both parties had substantial roots in Nigeria, nor is it a case such as in El Fadl and El Fadl, where notice to the wife of a talaq divorce would have been of no value to her. Nor is it a case such as Globovich, where both courts were aware of the other's interest and both parties were participating in both proceedings. And then paragraph 71, taking all this into account, my conclusion is that justice to the husband requires that recognition of the Ukrainian divorce be refused. Given the false position in which the wife put the Ukrainian court, this conclusion does not represent any lack of comity between the two jurisdictions. In my view, the approach to an application of this kind should not be governed exclusively by pragmatic considerations, although these will weigh heavily. The exercise of discretion must also be informed by a sense of basic fairness. When considering the obtaining of an order that is of great importance to most people, plain dealing must count for something, and it would be undesirable if a party who is fully participating in proceedings in one jurisdiction can unilaterally start proceedings in another and then expect recognition of a divorce effectively obtained in secret. Such a perception can only encourage unruly recourse to other jurisdictions whenever things are not going to plan in this country. My Lords, paragraph 71 of Dover and Yates, in my submission, is particularly relevant and helpful, as I say here, and I would invite the Lordships to have that in mind. Just moving on then, deal perhaps more briefly with the case of Leo and Lee, case Mr. Justice Mostyn, Volume 1 of the Family Law Reports, 2016, page 533. This was a Malaysian divorce. If I could just draw your Lordship's attention to paragraph 32, which one of the authorities bundle. On the other hand, there is the compelling argument that to decline to refuse recognition in this case would be grossly unjust and would in effect reward dishonesty and sharp practice. It would send out a signal that conduct such as I have described is tolerable. As Lord Hewitt, CJ, Chief Justice in Crown against Sussex McCartney, volume 1 of the King's Bench reports 1924, 256, at 259 famously stated, justice should not only be done, but should manifestly and undoubtedly be seen to be done. No one could conclude that justice had been done or been seen to be done were I to decline to refuse to recognise this violation of divorce. And so, my lords, it's the same sentiment. However, it's expressed as fairness, plain dealing, justice must be not only done but seen to be done. And all of those expressions in my submission are English standards. That is, in my submission, the test that the court has to obtain. So moving on, my lords, to my submission.
There's nothing else in the other authorities where we're in the bundle that you want to refer to?
While we're there, perhaps the case of Chugh and Chugh, first instance decision, Mr. Justice Mostyn, in volume 4 of the Weekly Reports 2017, page 111 of the bundle. His Lordship addresses the issue which your Lordships have raised and questioning whether it's finding of fact or evaluation or indeed broad discretion. Paragraph 29 of his Lordship stated, Section 51, subsection 3 on its face gives the court an apparent discretion whether to decline recognition. In quotes, recognition may be refused. However, as in so many other instances, this seeming grant of a pure discretion does not in fact vest the court with an unlimited power to do what it considers just. An inquiry under Section 51, subsection 3 is evaluative rather than discretionary. If the inquiry under Section 51, subsection 3a leads to the conclusion that no notice was given, but that it was reasonable for notice to have been given, then that will inevitably drive the conclusion that recognition should be refused. Equally, if the inquiry leads to a conclusion under Section 51(3)(2) that a party was not given a reasonable opportunity to participate, then that finding will drive the conclusion not to recognise. In each case, the court reaches a value judgment rather than a discretionary one, and that value judgment is exclusively informed by the concept of reasonableness in each instance. It is true that in Elfardle, Mr. Justice Hughes cast his decision under Section 51(3)(a) in the language of discretion, but a proper analysis shows that he in fact made the value judgment on the specific fact, and no notice in that case was not unreasonable, because had that wife been given notice, she could not have resisted the Lebanese divorce anyway. In Globovich, the Court of Appeal, Lord Justice Thorpe explained that if a breach of public policy is proved under Section 51(3)(c), then that will be the end of the matter. Recognition must be refused.
Yes.
So, my lords, in my submission, there is a large note, Mr. Justice Mostyn states there, and they've already submitted the discretion at the second point, taking the approach of Mr. Justice Holman, that it is a two-stage approach. The discussion at that second stage in my submission is limited.
Thank you.
Perhaps I want to draw your lordship's attention also to paragraph 31. Decision. For the reasons given above, I consider it potentially misleading for the first proposition to refer to applied judicial discretion. The second and sixth propositions both refer to asking whether the petitioning spouse in the other jurisdiction has taken reasonable steps to notify the party. Indeed, in the sixth proposition, the deputy judge says the focus of inquiry is upon the actions of the petitioning spouse. I agree with Mr. Scott, Queen's Counsel, that this overstates the position. Section 51(3)(a) is cast in the passive voice. It does not presuppose that any action needs to have been taken by the petitioner. In this jurisdiction, before the advent of the Family Procedure Rules of 2010, the default position was that the court would serve the process, not the petitioner. See 212, 2016 WHCR 216.4. Many other countries maintain that as their default position. The focus of the inquiry is on whether the respondent was given reasonable notice by whatever means, not on whether the petitioner gave.
Yes.
So, my Lord, turning now to my submissions against that legal framework, as I indicated at the outset, I have two principal submissions. The question, obviously, is whether such steps should reasonably have been taken to give notice of these proceedings to the appellant, with regard to the nature of the proceedings and all the circumstances to be judged by English standards. In my submission, the judgment of no reasonable judge could have found here that they were. Firstly, Mr. Allen, King's Counsel, was plainly wrong in concluding that reasonable steps were taken, because he failed to have regard to the procedural requirements of service as judged by English standards. Secondly, the husband knew that the wife was living in England and the parties were engaged in proceedings in England, but at no time did the husband inform the wife or the court of the Indian proceedings. There was a lack of plain dealing or a lack of fairness or natural justice, however you express it. And Mr. Allen KC failed to take that into consideration. So first of all, in relation to the procedural requirements for service, it's my submission that the judge failed to do that. In his judgment, the steps that were taken are set out at paragraphs 63 to 75. Page 95. Core bundle.
Yes.
I should say, my lord, that the way that the evidence in respect of service came before the court, you see no doubt from the judgment, was highly unsatisfactory. The envelope at, which will come on to page 173, wasn't in fact served until the morning of the third day doing submissions after the evidence had been taken. And the extract from the court file at page 175 was served during the course of closing submissions. All of which was very unfortunate.
So those, in particular, the service documents were not dealt with during the course of oral evidence at all. And we don't have a transcript of the evidence or anything, but what were any questions asked of the wife about her knowledge of the proceedings or the matters addressed in those service documents?
It was Mr. Chugh representing himself, and a QLR had been appointed to ask questions of wife. Specific questions that were asked. Just turn my back on. I'm being helpfully reminded that page 95 of the supplemental one My lords, it's page 112 of my supplemental bundle. This should be an email.
Sorry, can you give the page again?
112.
Thank you.
There should be an email dated 19th of June 2024.
Yes.
There's a highlighted paragraph, which is an email to the single joint expert, Ms. Sirajam, which sets out how the respondent put his case. And so in terms of the questions that were put to the appellant, the questions were generic rather than specific from recollection.
Of the questions, presumably on page 113, aren't they? Or not? At the top of the page, 113, addressed to the respondent.
Yes, the respondent was asked to provide all the details of the divorce proceedings in India, including the reply to the expert's questions about filing the power of attorney in the court in India in divorce proceedings, and if the court recognised it. How many times the notices were served, and if the notice was published in any newspaper anywhere, how many hearings were conducted. And it was asked to to kindly provide all information about the proceedings and the translation of all the documents as soon as possible. And then his explanation, as I already indicated, my lords, is page 112, the email of the 19th of June, where he doesn't, in fact, provide the information requested.
And then you took us to 175, didn't you? This is the document arrives on day 3 of the hearing,
Yes.
which, according to the transcript, I think it was the 21st of February, the transcript of the judgment, and I noticed a couple of stamps on that page 175, 21st of February, including, if you look just to the right of the top hole punch, 21st of February 2025, and that seems to be the notary. You get that by comparing the name with the stamp in the bottom right hand corner, attested advocate notary. So presumably the attestation relates to the appropriateness of the translation.
Yes.
But what I don't understand, there are also dates in type on that document of 29th of March 2022, which seems to might have been the date of the translation.
Well, no, my lord, that's.
Oh, that's the date in the
the
High Court
hearing.
procedure, the hearing.
Yes,
Yeah,
yes.
yeah. Okay.
And so, and it's not challenged in
No.
Mr. Allen's judgment that he's finding in relation to that, I mean, come
But
on.
going back to the expert's question, if you look at the heading towards the top of that page, in compliance with letter number 2422, dated the 16th of January 22, from the High Court, which must be in India, presumably. The date is fixed for so on and so forth. But this is the document that turns up 3 years later on the 3rd day of the hearing.
Yes. So clearly, I should mention that that document was available at the time to be provided to the expert, and yet it wasn't.
What on earth is this said to be? It doesn't look as though it's a document issued by the court.
It was said to be taken from what's called in India the docket.
Well, is it?
Um,
That's why I went to the top of the page. It's in compliance with a letter from the court. And this, just below the 4th of March, there's reference to paper book is presented, which I think the judge refers to in his judgment.
yes. Well, you see on page 174.
I see. That what's
that's-
175 is a translation of this.
Seen on
And this is what the judge refers to at 71 of the judgment.
yes.
But what a paper book is, who wrote it,
It's not clear.
well, in fact, you get a bit more of a clue, bottom of page 97 of the bundle. I accept the judge says it was extracted from the court file by H's Indian lawyers. So it's something on that basis produced by his lawyers, but possibly not the court's own docket, whatever that is.
Okay, yep.
So, Lords, in relation to the power of attorney, the judge's analysis begins, paragraph 63, with reference to power of attorney. Now, the issue of the power of attorney, the question of that was something raised by the respondent, something that he sought to rely upon. And Mr. Allen, King's Counsel, found that it was something of a red herring. Now, we don't take any issue with that. Our position is that it is a red herring. It's clear that the husband had to take proper steps to serve the wife, knowing, as he did, that she was in London. And so the judgment, having said that it's a red herring, then doesn't go on to consider the power of attorney any further.
Sorry, where's he say it's a red herring?
Paragraph 88.
Thank you.
Or 89.
89, yes. And so we signed the power of attorney. It's not something, our position is that it's not something that the respondent can rely on, nor difficult to take into consideration in his judgment.
I don't find this a very easy paragraph, but I think he's maybe using red herring in a different sense to that which you use it, because he's saying it doesn't matter whether the court documents were sent to the father's address pursuant to the power of attorney. It doesn't matter whether the power of attorney was registered with the relevant court. It's a much simpler question, and he resolves this in terms of the wife having treated the her father's address, as her primary address for service. So it happens it was expressed in the power of attorney, but the status of the document, seems to be the red herring, insofar as I understand it, he's talking about.
Yes. But, well, as I thought, this is clear from our submissions, that's simply not.
But how was it known that this power of attorney existed? For example, by the respondent. I mean, I don't think the judge deals with that.
There were other proceedings in Noida in which it had been registered, and so perhaps it had come to his attention through them. But I can't say further than beyond that which proceedings those were, because there were a lot of proceedings ongoing at the time. Right. I'm being told it was in fact there was an application by the husband under the Hindu Marriage Act for restitution of conjugal rights, and it was in those proceedings that it was registered. So, just returning to the steps taken by the respondent to serve. These are set out in judgment paragraph 64. 64. The judge set out reference to the husband's divorce documentation. The Indian divorce petition, dated 5th of July 2021, appears at page 3 of the bundle, supplementary bundle. So this divorce petition is dated the 5th of July, as I said, 2021. It gives the appellant's details as Latika Arora and Latika Chugh, W.O. Sandeep Chugh, which was understood to be wife of R.O. 25 Shivaji Colony. It's not clear what R.O. was. Sonipat, Haryana, 131001. At present, at 73 Neville Road, London, UK, E79QU. So it's quite clear, Lords, that the husband was aware that the wife was living at that address. But no steps were taken to serve her there. And then he gives an alternative address, also at Bureau Vertias Consumer Product Services. And then he gives an email address, he gives two email addresses. Tika Arora, and Tika Arora. Goes on to give a WhatsApp number. So then we come, my lords, to in fact what happened was that petition was issued on the 5th of July 2021. No attempt to serve it was made until 7 months later, on the seems to be the 7th of February 2022. We come to the India Post printed receipts, page 104 of the supplementary bundle. My lords, we did have those receipts in the bundle. From memory, the only it was before the court in respect of service when the trial started.
Sorry, can you remind me where they are?
Page 104.
Thank you. Yes.
We have those, and it's clear that having issued back in July 2021, the respondent chose to sit on the petition effectively and not to serve it for some 7 months. All the while, proceedings were ongoing in England, but I'll come on to that. Shortly. So then, in chronological order, we have the envelope, which wasn't served until the third day after the conclusion of evidence, and that appears at page 173 of the bundle. And obviously, my lords, it's highly unsatisfactory that this envelope was served and relied upon in the way that it was. And in my submission, clearly in those circumstances, any weight which the judge attached to it should have been exercised with the utmost caution.
Sorry, what does that mean?
Because of the way in which it was served, and there was no opportunity to test it in evidence. Any weight or findings that the judge made in respect of it ought to therefore have been made extremely cautious in making.
Is this a like way of saying you should have found it was not genuine, or?
Well, I'll come on to my submissions about it, but you'll see in the judgment that the judge does in fact place significant weight in his judgment on this envelope, and my submission is that he shouldn't have done that in these circumstances.
So what I'm trying to work out the relationship between page 104 and 173. What's the relationship between them? What's at 104?
So 104 is the record of postal receipt from the court, which was found to be from the court. So the court posted.
It seems to be dated the 7th of February 2022.
Yes.
So I had assumed that that related to the attempt to serve the initial papers at the father's address. Is that correct?
That's correct. That's
Whereas what
the
we're
judge
looking
found.
at page 173, according to the index to the bundle, is we're given there. Well, we're told that that's notification of the grant of the decree nisi, isn't it? Or
In page 173. Of
oh, is this the envelope?
This is the envelope.
This is the
yes.
February 2022 envelope
Yes.
that returned to the court.
Yes.
According to the index.
Yes.
So
it's the notice of the divorce proceedings.
So at the bottom left on 173 it says fix of 4th March 22. It says refused. It looks like 11th February 2021.
Page 173, my lord. Do
Yes.
You have, check that I've got
The manuscript refused. It has 11th February 21.
Yes.
So is it
Is it refused or is that on
Perhaps it would help
Yes,
if I refer
return.
your lordships to the
No.
judgment where Mr. Allen deals with this. and
Yes,
says,
okay, thank you. Yes. Returned, he thinks it is.
So paragraph 65, he deals with the two India Post printed receipts which stated on 7th February 2022 at 11:25 AM. Two identically weighted letters packages were posted by the family court to the addresses Sonipat and a different PIN number, Noida, UP. These correspond to the two addresses that were given in H's divorce petition. And then he talks about a submission made that they may have been fraudulent and rejects that.
When you talk about the circumstances in which it was provided, is this a document provided also on the third day of the hearing?
No, the
No. I don't follow.
printed receipts were in the bundle at
Yeah.
the time of the hearing.
Yes, but when you talk about the document at 173 and you refer to the circumstances in which that was provided,
Yes,
what are you referring to?
the one at 173, the envelope.
Yeah, I understand that, but
Yeah.
what are the circumstances
So
in
that
which
was,
it was provided?
it was served during, it was the third morning of the trial.
That's what I wondered. So is this because the judge in his, sorry to be slow, but the judge in the judgment at 71 talks about the first two additional documents provided by the husband on the third morning. And that's the translation we saw previously provided by the notary. Yeah?
Yes.
So what was the second? Is this the second?
was the envelope.
Oh,
Yes,
okay.
at 1/7.
I'm sorry to be slow.
No, it's, so moving on then to the envelope at 173. The judge, paragraph 69 deals with this. The envelope that H subsequently provided has a script on it under the words returned 11th 2nd 2021. H translated these words as recipient is saying she is abroad and they refused to accept it. W translated them as she's outside India and the people in the house cannot take it. Both are broadly similar and indicate that an attempt was made to deliver the envelope at W's father's property. It said that W was abroad and delivery was refused. Goes on to say, it is of note in this context that in her oral evidence on the second day, W stated that if my father had got it, he would have signed for it, and if he had got the petition, he would have told me. And as he didn't tell me, he didn't get it. It would appear from the subsequent provision of the envelope that at least the first of these two statements is incorrect. I'm afraid, my lords, I don't follow the reasoning at all in respect of that last section of that paragraph. So, my submission, just looking at the envelope at 173. Returning for the moment to Mr. Alan Casey's judgment, paragraph 70. He says, it is of note that the outside of the envelope made it clear that the sender was the Indian family court. It also gave both parties' names as if in litigation, i.e. with a V/S, included reference to the HMA, i.e. the Hindu marriage act, gave the case number and also the date of the next hearing, 4th of March 2022. Therefore, anyone looking at the envelope gleans some understanding of what it may contain, even if they refused to accept the same. Well, in my submission, Your Lordships, that is highly doubtful. There's no idea who might have seen it. Reference to the use of the word they, it could have been anyone, whether they were part of the household or not. It could be a brief conversation between, perhaps presumably the postman, or we don't know, but I'm assuming for now the postman and whoever they spoke to, whether they were really able to read or not. There's nothing signed for, as you might expect. It wasn't sent by registered post. It could have been, the reference to HMA could have been referring to the proceedings under the Hindu Marriage Act, the restitution of conjugal rights. So there's absolutely nothing on the face of that envelope which indicates anything other than it was something from the Indian family court, and whether it was received by who is anybody's guess. So the judge goes on then, paragraph 75, to find, in my view, it is clear from the foregoing that an attempt was made to deliver the divorce documentation at W's father's address, but he or someone on his behalf refused to accept it, and this refusal was sufficient for the Indian court to deem good service and thereafter to hear the case notwithstanding no appearance by W. Well, first of all, there's no, as I said, reference on that envelope to divorce documentation. It simply doesn't follow that it was seen by W's father or indeed anyone on his behalf. What does appear is from the court document is that it is clear that the Indian court did eventually make the divorce order, and so must have been presumably satisfied. But what that amounts to, my lords, is a finding effectively by Mr. Allen that what he was doing was simply relying upon the position in the Indian court. I'll come on to the chronology, but as in the case of one of the Nigerian cases, in fact it might be Duper Johnson itself, no notice was given to the Nigerian court in that case, otherwise it was found that they wouldn't have made the divorce, and I'll submit at this point that would seemingly, that would have been the case, that would have been the case here as well. So the judge was wrong for that reason to simply rely, as he does, on the acceptance by the Indian court of that point of good service. And also it's important to bear in mind that at that point the appellant was seeking to set aside the Indian divorce, and indeed still is. I believe that's still the case, that hasn't been resolved, but the appellant was seeking to set aside the Indian divorce on the grounds that it hadn't been properly served. And so, in terms of service and the judge's conclusion at paragraph 89 to 90, where he sets out his conclusion, and on into paragraph 90. In my submission, for this reason, in addition to my submissions about natural justice, which I'll come on to, but for this reason, the judge was wrong to find that reasonable steps were taken, and indeed paragraph 90, where he finds, I'm satisfied that H did, in my submission is an extremely surprising conclusion to reach. There's no reference, moving on to what one would have expected, and I should make clear, my position is, our position is not that we expect strict compliance with the CPR or CPR, but it is helpful to have that in mind when considering what should have happened in terms of service. And indeed, it is in many ways similar to that
If this had all been put on the table in advance of the hearing, so that the husband knew that the father had a power of attorney which extended to divorce and receiving documents from the court, wouldn't it be reasonable to give notice by serving in accordance with the power of attorney? I appreciate there's a different point that it all came out very late after the evidence, and perhaps that wasn't fair. But if it had been done properly in advance, what would be wrong with notifying the proceedings in that way?
Well, I don't seek to avoid the question, but in terms of the judgment, that's not the basis on which the judge.
No, he says it's a red herring, but assuming it's a proper fish.
Well, my lord, that's as I say, not something that the judge addressed. It's not something that was therefore written before the court. And in terms of there was an issue really. There was what would have been a strongly argued issue about whether a power of attorney in a separate case would have been valid in these proceedings, and that wasn't something that was ever really grappled with.
So you're saying that if that had been the way it had been argued, the expert would have been asked, was that legitimate would that have been legitimate under Indian procedural law?
Yes.
Because it seems clear from her report that powers of attorney need to be registered in particular proceedings for the purposes of those proceedings. And you're saying that those issues weren't explored because it wasn't the way the case was put.
Sorry, Marsh, could you just give me a moment, please?
Yes.
Oh, it's at page 163 of the bundle. This is the part of the single joint extra.
Yes.
Paragraph 2, down the page. The expert says that the fact that a power of attorney was made by Ms. Latika, appointing her father, Mr. Komal Krishnanarora, as agent on 10th of August 2021. A copy of the power of attorney was not filed in the court. The court did not accept and recognise the power of attorney, as there is no mention about in the divorce decree dated 20th September 2022. And as per the procedure, no notice and summons was served on the name of the attorney, Mr. Komal Krishnanarora, any time during proceedings until the divorce decree was
Who is
read.
Mr. Aurora?
That's the appellant's father.
Yeah, yes, thank you. I mean, the first part of that paragraph, the sentence, the language isn't quite complete, but you get a similar statement, perhaps slightly clearer, at page 147 to 148 in the summary. The bottom 147, penultimate paragraph, Mr. Sandy informed me, sorry. The court was only the court was informed about the power of attorney, not submitted. So it seems like the court was told about the fact of the existence of the power of attorney, but wasn't given a copy of it. And then that follows on to the following page.
Well, is that page 4 of the report?
Yes, bottom of page 4, 147 of the bundle. In this particular case, the power of attorney was not accepted and recognised by that under the procedure, but they had knowledge of the power of attorney executed by Ms. Latika. There's a slightly quaint language. There wasn't even a whisper about it in the divorce decree.
Well, in relation to that, my submission is that, as the expert says, it seems what she says, its meaning there is that in the divorce decree dated 20th September 22, there's no mention of it. And so, in response to your lordship, what Justice May point about the power of attorney, the existence of the power of attorney make a difference. In my submission here, what the experts say is that in these particular proceedings, there's no mention of it, and it would have been necessary for the technical vote to be regarded as valid service in India.
But isn't the question whether it's valid service in India applying Indian standards, whereas we're interested in English standards? And what the power of attorney says, essentially, is that because I'm abroad, I'm unable to look after legal matters related to my disputed marital life, including divorce. So I'm appointing my father to look into all affairs relating to legal proceedings. So, faced with that, and thinking to himself, well, I have to give reasonable notice of the proceedings, why not serve it on the father? Sorry, not serve it, why not notify the father?
In my submission, reference to fairness and English standards requires not, as I said, not strict compliance with an English approach. and it's one of the circumstances to be taken into consideration. Not necessarily determinative. It's one of the circumstances which the judge might perhaps take into consideration. But the position is quite clearly here that in terms of the Indian court, it wouldn't have been sufficient for the Indian court, and that in my submission is important. Both parties should be taken to know what the procedure is in India, and yes. In terms of the power of attorney, that was registered in separate proceedings, and so it shouldn't be permissible for the husband then to use that effectively against her in separate proceedings. So moving on, in terms of service could have easily been connected by, for example, email. My learned friend, I anticipate, will say, well, the wife had indicated that she didn't want the husband to contact her by email. That's page 21. Is it 21 of the supplementary one? There's an email dated the 9th of August 2021 from the appellant to the respondent. Got the information from your solicitor, Lena, that you have removed her from the case and are going to act in person. Please note that I have blocked you on my emails as per my last email dated 4th of September 2021, and you will not be able to communicate with me. It would be better if you will look for another lawyer, solicitor, to represent you, to communicate with me, since all your emails sent to me will be deleted on arrival. So, just to continue. I'm not going to take any email from anyone else on your behalf except from the UK's lawyers, solicitors, official email ID, so please do not send me the emails from different email addresses. This is because of your threatening email sent earlier and my replies already sent for the same.
Sorry, I'm behind. Can you remind me where that email is?
It's at page 21.
Thank you. Yes.
Which, as it happens, is one day before the date of the power of attorney. I don't know if that's a coincidence or not.
So the appellant isn't saying that she's not contactable by email. In fact, she's saying you have to instruct solicitors or someone else to communicate with me via email. And her email address was clearly known to the respondent. There's no reason why you could not have sent the divorce petition by email. Indeed, eventually, when the divorce itself was sent, and apologies, there was an email notifying the the appellant eventually on the 19th of July 2023. That was sent to the appellant's email address by Goodwin's family, who had been instructed by the respondent. So no reason I submit earlier why the contract being served on her by email by solicitor. If it had been otherwise, it ought to have been sent to her last known or usual postal address, and quite clearly from the divorce petition we've seen that the respondent knew that she was in London. He knew the precise address.
Can you just help me about the other proceedings? The first set of proceedings, well, there were a number of proceedings in England. There were the proceedings brought by the husband under the inherent jurisdiction, which were determined by Mr. Justice Mostyn, and they started on the, according to the chronology, on the 8th of May, 2021.
Yes.
So were both parties represented by solicitors in those proceedings?
The judgment's in the bundle at the Lord.
Yes, so the husband was represented by Dawson Cornwall and counsel, and certainly at the hearing, the wife represented herself.
Yeah.
So those proceedings were in existence from the, according to the chronology, the 8th of May 2021 to the 12th of November 2021. So presumably documents were being served backwards and forwards during the course of those proceedings.
Yes. And at no time can I come on to this very point.
Are you going to come on to the
Well,
proceedings? Okay, then
yes,
do it when you come.
Chronology, yes.
Yeah, do it when you come to it.
Yeah.
Sorry, I got distracted.
Um,
Yes, so we were saying eventually when the decree was sent, it was sent by his solicitors to the wife's email address
yes.
on the 19th of July 23.
I believe that's in the bundle.
Yes, page 46. Yes,
I'm just going to find the page reference for that email from Goodwin Family Law.
it's page 46 of the supplementary bundle.
Great. Yes. So the face of the divorce petition, the Indian divorce petition, makes clear that the husband knew at present living at the address which was the former matrimonial home in London, and so she ought to have been served there, but there were no steps taken to serve her. Or, Lords, there should have been an application for substituted service. In India, which would have
You using the word service, really, it's the statute talks about notice. So really you're saying that notice could have been given to the wife by sending them to her address in London, by sending them by email, by sending them. Did she have solicitors acting for her in any of the proceedings?
just check that.
Okay, when you come to the proceedings, to deal with the proceedings, can you
Yes.
tell us that, please? Yes.
Yes. And could have been served by WhatsApp as well, but they weren't. So just in terms of Mr. Allen's findings. I've already made the submission, I think, my lord, but his conclusion amounts to a simple endorsement of the Indian court's acceptance that the wife.
Sorry, of the
Indian court's acceptance that the wife had been served. It doesn't comply in my submission with English standards and regarding service, and is plainly wrong, particularly when he knew that she was living in London at a particular address. And just to go back to the test in Johnson, point 6, whether the petitioner's spouse has taken reasonable steps to notify the other party is the test, not whether the respondent's spouse knew about the proceedings. In terms of the judge's finding, in terms of the placing of reliance by the judge on the fact that the refusal of service was sufficient for the Indian court to deem with service, it's highly unlikely, Lord, that the Indian court was aware of the English divorce proceedings brought by the wife, because otherwise one can reasonably assume that they wouldn't have made the divorce. By the date of the first hearing in India, which was the 4th of March 2022, the wife had obtained the decree nisi on the 21st of December 2021, which had been properly served on the husband by email, pursuant to an order of Deputy District Judge Wilkinson, who deemed service 48 hours thereafter, which is acknowledged. And so as part of the plain dealing, one of the factors in relation to that I submit the court has to take into consideration is that the strong likelihood that had the Indian court been told about the decree nisi in England, it would not move the Indian decree of divorce.
Is that a point on reasonable steps or discretion?
Well, I say it's one of the circumstances that the court has to take into consideration when deciding whether reasonable steps have been taken. So, at whichever stage your lordships address it, it's one of the factors I say you need to have the respect taken into consideration.
Well, you were making 2 points rolled into one, as I understood it, which included plain dealing. You were saying on the one hand there's the wife telling the husband of what was going on in England, but there wasn't reciprocity in terms of plain dealing. But that's a separate point from what the Indian court would have done if they'd known about the English proceedings.
Yes.
And that second point isn't essential to your plain dealing submission, as I understand it.
No, I agree.
Yeah.
Continuing with that, if reasonable steps were taken in this case, it would mean that by English standards, a party could serve an opposing party by sending documents to that party's father's address or other relative, or in the knowledge that the opposing party wasn't there without prior or subsequent authorisation from the court. And in my submission, that would be plainly wrong. And further, that service would be good even when the documents were returned unopened, as they were, And in my submission, that cannot be right. One can quickly see how that would be used to ill effect by those who wished to do so, and that comes back to the point about plain dealing.
Yes.
So, moving on, my lords, to my second principal submission, which is that parties were engaged in proceedings in England, and at no time did the husband inform the wife or the court of the Indian divorce proceedings. So, perhaps, my lord, at this point I can address the chronology in some more detail. So, at the time the husband made his application for divorce in India under the Hindu Marriage Act, it was the 5th of July 2021. There had already been a directions hearing in Family Law Act proceedings before Deputy District Judge Byrne in the Family Court at East London on the 24th of June 2021, at which both parties attended, albeit remotely. So clearly the husband was aware, it was in the petition itself, that the wife was living in the family.
We don't have those proceedings, do we?
No. So the wife filed a divorce petition in England on the 30th of July.
It says the 31st in the chronology. Is it the 30th?
Double check, my lord.
I don't suppose it matters, but just for accuracy.
It might be that the two separate dates. It was issued one day and then.
Yeah, possibly.
You can double check.
Yes.
So on the 30th, possibly 31st of July 2021, the wife filed a divorce petition, which had been properly served on the husband, was found by Mr. Justice Mostyn, paragraph 41 of his judgment, which is at page 88 of the bundle, the supplementary bundle in Warsham proceedings. So there were 4 sets of English proceedings instituted between July 2021, when the Indian petition was issued, September 2022, when the divorce was obtained. So there was the Family Law Act proceedings, which commenced on the 7th of June 2021. And there were hearings on the 27th of May, 12th of July, 27th of May 2022, 12th of July 2022, and 14th of July 2022, before Recorder Sterling.
Before you referred to paragraph 41 of Mr. Justice Mostyn's judgment, in which he refers to proceedings having been, the divorce proceedings here having been issued, properly served on the father. The father has not responded to the petition, and in his evidence before me, the father appeared unwilling to consider divorce at this stage. So you would rely on that as part of the picture,
Yes, my lord.
when the husband had in fact issued divorce proceedings on the 5th of July 2021, so some months before the hearing, before Mr. Justice Mostyn.
Exactly.
Yes.
So, my lord, I referred to the Family Law Act proceedings, which commenced on the 7th of July 2021. Hearings on the 27th of May 2022, 12th of July 2022, and 14th of July 2022 before the Court of Stirling. And just at that point, I'll highlight, my lord, and I'll return to the 14th of July 2022. At that hearing,
Sorry, which page is that?
270.
Thank you.
At page 70 of that order, your lordships will see lengthy recitals, etc., which is helpful in this case. Paragraph 12. And upon the court noting that whilst the respondent has applied in India in February 2021 by way of petition for restitution of conjugal rights under the Hindu Marriage Act, 5, that the parties confirmed to the court that the applicant has not put in an appearance in such proceedings and no substantial hearing has occurred therein. The respondent confirmed to the court that the aforesaid proceedings were not divorce proceedings, and both parties confirmed no divorce proceedings, including any associated financial proceedings, had been instigated in any jurisdiction. Well, in fact, that representation, that confirmation on the part of the respondent was a lie, because 9 days earlier, the 5th of July, he had a course to be issued on his behalf, the application for the divorce in India. Just returning then to the other proceedings that were ongoing. You've already mentioned the proceedings of Mr. Justice Mostyn. There was the main suit filed on the 30th of July 2021, and financial remedy proceedings issued by the appellant, the Form A dated the 3rd of February 2022, which were all served by the as required by the rules. The fact of divorce in either jurisdiction is a relevant consideration in all of those 4 sets of proceedings. But there was no mention by the husband of any divorce proceedings in India, nor did he take any steps to serve them. And as we've seen, attempt at service that he relied upon didn't happen until February 2022. I think I've already covered the point, but just to be clear, there were 2 hearings when the husband was expressly asked about any divorce proceedings. He didn't bring the fact of the Indian divorce petition to the court's attention. Was the hearing in the wardship proceedings before Mr Justice Mostyn on the 2nd and 3rd of February 2021. And the hearing before Recorder Sterling on the 14th of July 2021. At which Mr Recorder Sterling had the presence of mind to record the position.
Sorry, the hearing before Mr Justice Mostyn in the wardship proceedings, did you say 2nd to 3rd of February 2021?
November 2020.
November, yes.
Yes.
That makes more sense.
And you say the passage in the Justice Mostyn's judgment of 41 reflects the husband being asked whether there were divorce proceedings or about divorce proceedings generally.
Which page is that on?
So it's page 88.
Yes, I do say that. This is dealt with in the judgment of Mr Recorder Allen, King's Counsel, at page 102 of the bundle, paragraph 92 of the judgment.
Sorry, paragraph 92. Yes.
In my submission, the judge was wrong to dismiss, as he does, that finding of Mr Justice Mostyn.
He says it could be a reference solely to the English proceedings, whereas what the judge, Justice Mostyn, recorded was he wasn't interested in divorce at that stage, wherever the proceedings were.
And going further to reject, as he does, because he says in any event this was not the focus of that hearing.
That's another point again.
Yes, there's neither here nor there.
So just your submission is a plain misreading of paragraph 41. And I think your submission, so far as what was happening in English proceedings, that they were, I was going to use the word happily, but that's probably not an apt word, that they were serving documents on each other for the purposes of those proceedings, or sending them, giving notice, whatever you might call it. That doesn't seem to feature at all in the judge's judgment. So your submission really is that he ignored material relevant factors, including what was going on in the English proceedings, which clearly indicated the husband was very well able to serve proceedings on the wife for the purposes of those proceedings. I suppose you could make the point that it's particularly powerful in respect of the wardship proceedings, because those were initiated here 4 days after the divorce petition in India. And the husband could have served both on the wife at the same time if he wanted to.
Yes, exactly, my lord, yeah. So, my lords, the respondent's confirmation to the Court of Stirling and his representation to Mr. Justice Mostyn, but focusing on the recital as confirmation to that there were no divorce proceedings, and that none could be instigated in any jurisdiction. That lie was simply, not simply, was rejected by Mr. Recorder Allen as not material to my analysis and decision. Paragraph 104 of the judgment. It appears that Mr. Allen King's counsel regarded that as a point in relation to husband's credibility, where he says, although these are both instances of husband not having told the truth, they are not material to my analysis and decision. So he was addressing effective credibility. But nevertheless, he does find that it's not material. And in fact, in his judgment, he clearly doesn't regard it as material because he completely fails to take it into consideration. It clearly is a material consideration.
Well, you would submit that it's highly material, both that it was a lie at the time and that it remained a lie throughout. In other words, it was never corrected.
Exactly.
I think also you rely upon it in the context of the plain dealing argument.
So, in my submission, Lords, for those reasons, the judge failed to take these factors into consideration. They are clearly relevant circumstances that he ought to have weighed in the balance. He didn't do that, and clearly he ought to. And had he done that, then he would, no doubt, in my submission, have concluded that it wouldn't be appropriate to recognise this Indian divorce.
Well, first, that he would have concluded not reasonable steps, and the reasonable steps had not been taken. And then your submission is that he would have also exercised his discretion by refusing to recognise.
Yes. Lords, I anticipate that my learned friend will rely on paragraph 94 of the indeed does in his skeleton argument. This is page 102 of the bundle, where it refers paragraph 93 to the email sent by H's then solicitors Goodwin's family. And then wife replies stating, thanks for sending these documents over to me. This is the first time I had ever heard with the divorce proceedings H is mentioning. He never mentioned anything about the divorce being filed and the decree granted to him in 2022 to any of the courts in India or in the UK till date. And so Mr. Allen says at paragraph 94, I do not consider that W as being entirely truthful in this email. It may be that given service of the divorce documents was refused, W had not previously seen any of the Indian divorce documents. However, W accepted in answer to one of my questions. She has a normal relationship with her father. They frequently spoke about various court cases in India in which she and he were involved, where there was a party, or in this case, also represented W. I found that whoever was asked to receive the envelope with the summons, whether it was W's father or another individual, had refused to accept it, informed W of the same, particularly given what was written on the outside of the envelope. I am therefore satisfied, notwithstanding what W said in this email, that this was not the first time she had heard of the divorce proceedings. Well, first of all,
Sorry, just to be clear, the date of the email, is that from line 2 of paragraph 93, the 19th of July?
yes,
So it's the 19th of July email from your client to an email from the husband's solicitors of the same date,
yes,
and she'd just been served with an application notice on the 18th of July, in which he sought a stay of her financial remedy in this jurisdiction.
yes. So first of all, as we've seen on the face of the envelope, there's nothing to indicate there that's related to divorce proceedings. And indeed, it's not the finding that if it be said that it is, the wife knew about the divorce proceedings, it's not, in fact, a finding that she did. At its highest,
Well, it's a finding that she did know, but you say it must be wrong because if the envelope was not opened, you can't tell from the outside that it has anything to do with divorce, as distinct from the other matrimonial proceedings.
exactly.
I thought your other point was that this was only raised during the course of once your client had given evidence, and so it was not a matter that was raised with her at all
It is, exactly.
during the course of her, which is why you included 2 in the bundle.
That's right. And just moving on, my lords, to the issue of comity, which my learned friend also raises. If I could refer your lordships to, again, that passage at paragraph 71 with Labour and Yates. It's Justice Peter Jackson, as it was. Perhaps worth just looking at that again. Conclusion that his lordship reached in that case not to recognise the Ukrainian divorce does not represent, he said, his lordship said, any lack of comity between the 2 jurisdictions. In my view, the approach to an application of this kind should not be governed exclusively by pragmatic considerations, although these weigh heavily, comity, respect for other jurisdictions. The exercise of discretion must also be informed by a sense of basic fairness when considering the obtaining of an order which is of great importance to most people. Plain dealing must count for something, and and it would be undesirable if a party who is fully participating in proceedings in one jurisdiction can unilaterally start proceedings in another, and then expect recognition of a divorce effectively obtained in secret. And my lords, in my submission that applies to this case, and I would invite the lordships to allow the appeal.
Yeah, we have no other questions. Do you have anything else? No, that's it. Mr. Wilkinson, we have 5 minutes. What would you want to do? Do you want to? Should we stop now and start again at 2?
I'm entirely in your hands. I could make use of that 5 minutes if it were available to me. But
Should we 5 minutes? Why not? Okay, we'll give you 5 minutes.
in a nutshell, as we know, the ground of appeal turns on section 51(3)(a)(1). That's the specific provision. That's all this appeal concerns. You've been taken to that, so I'm not going to deal with that now. But it is very clearly stated that there is a positive obligation imposed on the courts by statute that the foreign divorce shall be recognised. So it's mandatory, unless there is a reason to refuse it pursuant to section 51. And there it stands as it may be refused. And the reason why I make this point now is because we submit that the wife looks at this through the wrong end of the telescope. And it's just this freestanding inquiry into whether it should be recognised or not. And this appeal is all about whether the foreign order, not whether it should be recognised, but whether this court should refuse to recognise it. And we say that's an important distinction. We also say that if there has been actual notice, it must follow that there have been reasonable steps to give notice. And so section 51(3)(a)(1) must be satisfied and the appeal must be dismissed. If there has been constructive notice, again, there must have been reasonable steps taken to put that party on notice. So section 51(3)(a)(1) must be satisfied and the appeal must be dismissed. Then we move on to reasonable steps. If the court is satisfied that reasonable steps have been taken to put the wife on notice, and it's important to note here, this is considering the nature of the Indian proceedings. This is a qualified test by statute and all the circumstances of the case. So it's not just a freestanding English consideration. It is considering the nature of the Indian proceedings. So if reasonable steps are found, even if notice is not given, section 51(3)(a)(1) must be satisfied and the appeal should be dismissed.
Notice is not given in the sense of not received.
Yes.
Yeah.
And so in conclusion on the stage 1 test, if the court is satisfied that there's been any form of notice in this case, or reasonable steps taken to put on notice, the appeal should be dismissed. And you don't even engage the stage 2 discretionary route. If we do get to stage 2, and we've seen, and I'll take you to this after lunch, but it's Oliver Soy, Mr. Justice Holman, where he makes it clear that you only get to stage 2 if you can't address this issue at stage 1. And he says that even if the court judges that there were not reasonable steps taken, then that merely opens the gateway. Section 51(3)(a)(1) provides for the court to refuse recognition on the basis of no reasonable steps without such steps having been taken. So, if reasonable steps have been taken, that's the end of the inquiry. But stage 2, briefly, provides where reasonable steps have not been made out, based on an Indian order, findings of an English judge, we say that's untenable. But if that's not right, when considering the discretionary route, we need to consider India as the natural forum. This is an Indian couple getting divorced in India, and there's been reference to Ukrainian proceedings and all these other authorities. And that's when someone has left the country to go and get a divorce in secret. In fact, in this case, that's what the wife has done. The proceedings were going on in India, and the wife has come to another country, not the natural forum, to petition. And natural forum I'll expand on later, but then we've got comity, which is at the heart of this appeal. It's at the heart of the statute. The statute itself originates from an international treaty, the Hague Convention 1970. The fact that both parties want this divorce, so there's no practical benefit. The undesirability of limping marriages, which again is addressed throughout these authorities. It could be 5 years between the original Indian divorce in 2022 and ultimately when it's resolved in this country, if it were resolved, it could be next year. There's still a lot to do in relation to the English divorce. There's a long period of limping marriage. Part 3 addresses the finances. That's not an issue. Now, deceit is a big issue in this case, which I feel I can't address in the time I've got left. But we do ask this court to consider the impact, the consequence of the deceit, 1, and 2, the deceit in all of the authorities. All of the authorities before this court refer to deceit in the foreign court. And that the point being is that from a comity perspective, it's not an affront to comity if we refuse to recognise the foreign order because the foreign court has been misled. That's not this case.
Thank you. So we'll stop there and start again at 2 o'clock.
Court rise if able.